Well, thanks for coming in again, Rodney. What can I do for you this time?
You're not going to believe this, Graham. We've actually just received a notice of adjudication.
You're kidding.
I just can't believe it. But I now got round to asking you what happens in this situation. So I'm afraid here I am again asking you. Can you tell me what goes in the response? What do we draft now?
I certainly can. Well, firstly, don't panic. We can sort it out. The first thing I always advise clients to do when being served with a referral document is to see whether there may be a procedural challenge. Has the procedure properly been followed?
Okay.
For example, has the dispute crystallised? In other words, are you still corresponding with the other side regarding certain elements of the dispute? And you could say that actually we haven't actually exhausted our correspondence. We've been asking for breakdowns,
Right.
etc. Has the adjudicator been validly appointed? It may be that the contract names an adjudicator
I see.
and they haven't followed the correct procedure.
Right.
Have the timetables been met,
Yeah.
etc. So it's the procedural challenges that we look at to start with to see whether we can actually knock it out at an early stage. If we can't, then we have to move on.
Okay, now I've dealt with litigation before about
Yes.
the burden of proof. I've heard lawyers mention that before.
Yes.
If we put a response in, does
Yes.
that change the burden of proof?
It does.
Oh.
The lovely legal saying is, he who asserts must prove.
I see.
The burden of proof, which in civil litigation is on the balance of probabilities,
Yeah.
now will rest upon you if you are putting in your response some things that you rely upon. You have to produce all the evidence in
I
relation
see.
to those documents, etc.
Can you tell me how we draft the response and
Yes.
what we can put in it?
I certainly can. There's no formal set way of doing a referral document, a response document. Usually what I do, I tend to try and take the adjudicator by the hand and respond paragraph by paragraph to the matters raised in the referral document. That way you cover everything. And also, obviously, you would have to support everything with some supporting documents and sometimes witness statements and sometimes experts' reports. So you respond by way of a narrative, paragraph by paragraph, to the referral document.
Well, it sounds quite detailed and quite time-consuming.
It
but
can be.
I appreciate that. This may sound like a stupid question, but can they reply to the response?
Generally, particularly under the scheme to the Construction Act, there is no right to reply to the response.
Right.
But in my experience, an adjudicator usually allows a reply, usually gives 2 or 3 days to say, okay, referring party, what do you have to say about that? So yes, usually there is a reply.
Then, after we've gone through that procedure, is that then up to the adjudicator then? Do we just wait his decision?
Well, actually, believe it or not, the adjudicator can allow a response to the reply, depending on what is in the reply, whether it's
Right.
controversial or not. So you have umpteen documents which are flying backwards and forwards between the parties and the adjudicator.
Oh, I see.
He will eventually draw the line on representations, and then he has the rest of his 28 days to make his decision.
Oh, I see. Right, I understand that. I was trying to work out the 28 days.
Yes.
And how that fitted in to all of this, whether it's 28 days from beginning to end.
It is. It's 28 days from the date that the adjudicator is appointed to the date that he makes his decision, unless there's this extension of
Right,
time.
so that's why we may get these extensions then.
That's right.
Oh, I understand it now, Graham. Thanks.
I understand you require some more clarification.
Yes, well, you've been so successful with two adjudications, almost running, in tandem with one another. What do we do when we get the decision and we know that no one's going to appeal it? and how do we get it enforced? Because
Yes.
it's all about getting the money at the end of the day, Graham.
It is. What I obviously would do, first of all, Rodney, having had a successful decision, is to write to the other side to remind them that they have to pay the award within the particular period.
Yeah.
If they don't intend to, that usually flushes out a response to say, actually, we're not paying because.
Yeah.
Thereafter, if there's no response or they don't pay, you then have to enforce that decision by way of court proceedings in the Technology and Construction Court, known as the TCC. And there's a particular process for it, Rodney.
Okay, I understand that then. So is the decision final and binding then?
It is. The adjudicator's decision is final and binding until the dispute is taken further by way of arbitration or litigation, depending on what your contract says. There's no obligation to take it further, and if you don't take it further, then the adjudicator's decision is binding and enforceable.
What if we spot he's made a mistake in
Yes.
his sums or anything?
Yes.
Can you challenge that?
The adjudicator is now allowed to amend some minor mistakes. Didn't used to be able to, but under some changes that were effected to the Construction Act a couple of years ago, he's now allowed to amend minor mistakes called the slip rule. So yes, if he has made a minor error, then he can correct it.
Okay, well that sounds quite straightforward. So the procedure then, we've got the decision, and you explained we go off to a court I've not heard of before.
Yes, unfortunately, Rodney, it's quite a complicated procedure in terms of documentation that have to be prepared. It is a section of the High Court called the TCC, the Technology and Construction Court. You have to issue proceedings, quite literally prepare a claim form, and you will need a lawyer for this process.
Okay.
You have to issue the legal proceedings. You then have to make an application with the proceedings for what's called summary judgment.
I've heard about that, yes.
That's quick judgment, where you're saying to the court, effectively, there is no dispute to this claim.
I understand.
With your application for summary judgment and your claim form, you have to again make another application to what's called a bridge time, because normally when you issue proceedings, the other side are allowed 14 days to respond on a form called an acknowledgement of service.
Oh, I'm familiar with that, yes.
The idea with this adjudication enforcement is the court are required to effectively enforce the decision within a 28-day period, which is akin to the 28-day period from start to finish on adjudication. So the court try to have a 28-day period of enforcement. So you apply to abridge the time for the sending back of the acknowledgement of service. Usually you apply for something like 3 days. So there's your claim form, there's your application for summary judgment, there's your application to abridge time, and you usually support it with a witness statement telling the judge exactly what's happened in the adjudication process.
Fine, I think I'm happy with that. So what happens when we've done all of this? What does the court do?
Yes.
And how quickly?
The court act quite quickly. In fact, the judge, there is a guideline in the TCC. They are required to respond within 3 days of the judge getting the papers to set a time limit. And the time limit ends 28 days hence. So they usually issue what's called directions, saying what needs to be done. Usually the other side obviously are entitled to put forward their evidence as to why they say the award shouldn't be enforced, etc. 24 hours before a hearing is arranged, the court require bundles of documents to be prepared so that they have all of the information before them to make a decision, and they fix a hearing.
So it's quite time intensive then, isn't it?
It is.
And again, it's more cost. It's just that the director's going to ask me, how much is all this going to cost?
I've got some good news for you, Rodney, on that score. Although you can't claim any cost in connection with the adjudication procedure itself, that's not the situation with enforcement.
Oh, good.
You're entitled to recover all of your costs in connection with the enforcement process, including the court fee that you initially pay
that's
out.
good news. That's good news.
So hopefully, Rodney, you recover my fees.
Okay. Once we have this judgment,
Yes.
the previous steps I've taken is normally to issue a stat demand if it's a limited company.
Yes.
To frighten them.
Yeah.
I presume we can use all those same steps of enforcement that we've used previously?
You can, because if the court upholds the award, then of course you can enforce it like any other court judgment, as you've said, by way of statutory demand, or you can send the bailiffs in, or you could register a charge over property, etc. So, as you say, all the usual ways of enforcing the judgment are available to you.
Okay, well, thanks a lot, Graham. Again, as usual, can you just send me a bullet point
Certainly,
summary?
Robbie.
And then I'm meeting the directors tomorrow because there is two large adjudications we've won, and they want to get on very quickly now and seek to enforce those.
Well, I'll be very happy to assist in that process, Robbie.
Okay.
And thanks for coming in again
No,
today.
thank you again, Graham. Thank you.
Thanks, Rod.
Thanks.
In this session, we learned about the potential procedural challenges that can be used to attack a referral notice and, if no procedural challenges are available, how to draft the response. We established that there are very strict time limits involved, and we addressed the grave consequences of missing one of those time limits. We discussed the nature of the adjudicator's decision and how to enforce the adjudicator's award in the Technology and Construction Court.